This case is about a mother who refers to her child not by his name, but calls him the child. That child's name is Karter Ambrose, and his mother killed him. Repeatedly called him the child. He didn't have a name, he didn't have an identity, which he testified. He was just the child, like an unnecessary piece of chattel or an object that gets thrown in the kitchen junk drawer. I told you from the start, you don't have to choose who did what. They are each party to the crime of each other. They are parties to each other's crimes. And there is no doubt that 2-year-old Karter was murdered. He was murdered by the two people who were supposed to care for him. Now, I get 2 opportunities to talk to you. So I get this opportunity, and then the defense is going to get to talk to you, and then I get to come back. But at this point, I kind of want to walk you through the indictment, because there's a lot going on, so I want to take it charge by charge. So count 1 is malice murder. All right? Now, the defense pointed out something, I think when talking about malice murders, murder that involved premeditation. Premeditation is not an element of malice murder. Malice can be formed in an instant, a depraved heart. It's an intentional killing of another without justification. And what you had in this case was testimony from the medical examiner who performed the autopsy, as well as the former chief medical examiner. Evidence of those injuries of the child. All right, not one bruise. There were multiple injuries. His abdomen, he had hemorrhage in his brain. He had an injury to his groin area, his scrotum, both external and internal. All right, these repeated strikes are malice. That is what malice is. They are repeated. They are intentional. And on a 2-year-old child, they are 100% a depraved heart. This was not an accident. Count 2 is felony murder. It's based on cruelty to children in the first degree. So this felony murder doesn't require malice. All it requires is the intentional committal of cruelty to children in the first degree, which then caused the death of Karter. All right? Cruelty to children in the first degree is the intentional infliction of pain on a child under the age of 18. All right? It caused the death of Karter Ambrose. Again, the injuries, the repeated blows on that child. Count 3 is the cruelty to children in the first degree count. Intentionally causes cruel physical pain to a child under the age of 18. Count 4 is felony murder. This is based on aggravated assault. An object which, when used offensively, is likely to result in serious bodily injury or death, caused the death of Karter Ambrose. All right. Now, in that indictment, and I didn't hide this from you from the beginning, the exact nature of the object being unknown to the grand jurors. And I told you I didn't hide the ball from you. You're going to have some questions. You may have some questions. What object was used? All right. All it has to be is an object, and you look at the nature of the object, how it was used, whether it's a baseball bat or a fist, all right, likely to result in serious bodily injury or death. Count 5 is the aggravated assault, which underlines the felony murder that I just outlined for you. Count 6 is murder in the second degree. Murder in the second degree is based on a negligence theory. Again, malice is not required. The only count that malice is required is the malice murder. Murder 2 does not. It operates differently. It's a negligence standard. All right. So here, the negligence caused cruel and excessive physical pain to Karter when he has a lacerated liver and has been sick all weekend and nobody gets him medical attention. That is the negligence. He should have gone to the doctor before Tuesday. And cruelty to children in the second degree. The criminal negligence, which I'll define for you. A failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by the failure to act. As the moments, as the hours ticked by, Karter slowly died. So remember the timeline. His time of death was November 17th, 2020. It was in the mid-morning. Time of injury was 24 hours before he died. So that was Monday morning. All the way up to 72 hours after that, which was Saturday morning. If you remember the timeline. Sunday was when Karter was not fine. There's a couple other things I want to point out legally for you. One is the statute of limitations. So there's dates in the indictment. They don't actually mean a whole lot. All the state has to do is prove to you that this crime was committed on a day within the statute of limitations. So it's easy on murder because there isn't one. All right. As it relates to the felonies, so you've got the aggravated assault, cruelty to children, second degree. All right, and a couple of the other ones, it's a 4-year statute of limitations. All right, so this happened November 17th. The indictment was towards the end of 2023. So it was November 17th, 2020. Indictment was in 2023. On my count, we're at 3 years, not 4 years. And remember, the prosecution doesn't commence at the start of trial. It commences at the time of indictment. So this indictment, regardless of the time frame complaining, was returned timely. Other issue that I want to point out, and I don't know, it really hasn't come up at this point or not, but the judge is going to read a bunch of the law to you, and in that is venue. You have to try a case. You have to where the crime was committed, usually. So in this case, the injury was inflicted in the apartment in Houston County. You were wondering why we kept asking, is that in Houston County? Because that is an element of the crime that the state has to prove. Right? This apartment complex is in Houston County. That is where Karter was from Saturday evening all the way until he was rushed to the hospital. During that whole time frame, it's all in Houston County. So I don't want you to get caught up by that. Thursday was the last day Kadeem saw his son alive. His 2-year-old boy on a bike. Drops him off at daycare, happy and uninjured. You'll never see Karter again, MF. Those were her words. Boy, how true are they? Friday, he's at daycare. He's happy. He doesn't seem injured. He eats his food. He wasn't throwing up. And the defendant picks him up. Saturday takes him to Granddad's house. He's happy, playing. He's uninjured. He's not throwing up. And then the defendant has Karter by herself for the rest of the day, Saturday, as well as most of the day, Sunday. And during the day, he's fine. She's the only person who has him. Boyfriend comes over. They have dinner. And that's when Karter is complaining of stomach pain at bedtime. And in her first interview with Sergeant Collins, she says that's when he was throwing up. It's not till the second interview that she changes her story. She moves it out to when she didn't have access to him. But that Monday, Karter is sick in bed, early morning hours. She goes to work. Boyfriend stays home with him all day Monday. Karter's throwing up again. Throws up overnight. He's complaining of stomach pain. Then Tuesday morning is when he's rushed to primary pediatrics. She drives out of her apartment complex within yards of the doctor's office and continues on her day, leaving Kiyon to deal with her dying child. Again, you don't have to decide who did it. You don't have to pick one or the other. It's not all or nothing. Alright? These two people had access to this child when he was symptomatic, the only two. Everybody else who came into contact with this child leading up to Saturday evening said that boy was happy. He wasn't throwing up. Karter never said, never told the defendant that Kiyon did it. He would run to me and point and tell me who hit it. He didn't do that. He didn't do that. And she doesn't know what's going on. She didn't know nothing about anything. She is not particularly worthy of belief. She changes her story. After the fact, she's making up reasons for how it happened. She's bringing up that it fell, maybe off the couch or the bed, fell in the bed, rolled back and hit his head. She's asking about CPR when Lieutenant Meadows was talking to her. There's a lot to do about asthma, underlying conditions. He was sickly. You heard those medical examiners. There was no underlying disease. His lungs looked fine. What he had was a 2-inch tear of his liver brought on by blunt force impact. And to claim that she doesn't know. I call 30 million times a day. I FaceTime. I always check in when someone else has my child. And she's right there. She's right there. The time frame for the injury when it was inflicted, right, is the closest to the time of death is Monday morning. So if you go back, she's the one who was right there with him the whole time. And according to her, she watches him like a hawk. I mean, she calls him a crybaby. He's dramatic. What a way to talk about your son. Whose autopsy photos have just been shown to the world. You'll never see Karter again. And then, once the injury's been inflicted, she calls Kadeem. Because he's EMS. And he doesn't come get the child. Boy, does he regret that. I can't imagine having to carry that guilt. I cannot imagine. So she leaves him with Kiyon. Because she's a single mother. What else am I supposed to do? Lets him deal with the problem. She left him hold the bag, but then doesn't blame him, which is a bit odd. Rather, according to Kadeem, the man that she wanted to take the child because he was sick, wanted Karter to go with him, when he discusses with her the autopsy report and injuries of the child, and if he finds out Kiyon did something, he doesn't know what he'll do, she gets mad at him. She gets mad at a father grieving the death of his son for having the audacity to suggest that Kiyon did this. Now, I think I brought it up in my opening originally, and that is reasonable doubt. You're going to hear beyond a reasonable doubt. The judge is going to instruct you on that. I spoke about it with y'all a little bit on Monday in my opening statement. And I like to think of it as pieces to the puzzle. Yes, this is a circumstantial case. I told you from the beginning we didn't have an eyewitness. There's no CSI Miami, 1 hour, DNA, solve the crime, let's go home. It's all circumstantial, but there are plenty of pieces to this puzzle. First one is that the defendant and her boyfriend are the only ones with custody even at the outset of the symptoms. She changes her story. Her second interview, she tries to point her story away from herself. She doesn't go as far as to blame Kiyon, but she starts to build her own timeline. She's never blamed Kiyon. She's even defended him. She calls him 30 million times a day. And let's not ignore the fact that this is a substantial injury. This is a 2-year-old boy with a lacerated liver, a 2-inch laceration. But that's not the only injury he has. He has multiple injuries, including to his groin area, his scrotum. And he's a crybaby. He cries over everything. That's what the defendant says. You're not going to sit here and expect me to believe that this child was not in serious pain. The 2-inch laceration of the liver, and that it was just a minor tummy ache. There's no chance of that. You're going to tell me this child wasn't in the fetal position, holding that stomach, rocking back and forth with a lacerated liver. And that's why Kadeem couldn't see his child. That's why he couldn't FaceTime or talk to that boy. Because remember, she's mad, she blocks him. He said it happens sometimes, but she's never refused him access to the child until the weekend his liver is lacerated. I have serious questions as to whether or not letting Karter go with his father or leaving him at home with Kiyon was not a setup to point this somewhere else. She tells others it's because Karter fell. And she doesn't tell the police that, but she tells daycare workers that. She tells Gazette that. Building this story. How could this have happened? And then she bragged about the investigative report, which is kind of an odd thing to do. And then when she testified, she couldn't even say Karter's name. Now, this isn't the only time I'm going to speak to you. I'm going to speak to you again. I'll have more to say. But this is not an accident. This is cold-blooded hate, murder, malice, depravity. No child should die like this. Thank you.
Once again, I'm Jeff Grove here representing Ms. Davis in this matter. I'm not going to whisper to you. I may do a little shouting. But I want everyone to hear what I have to say about this. Okay? First of all, Ms. Davis thanks you for your service. She understands how traumatic a case this really is. And it is. It's a sad case, as you'll ever want to hear. I'm going to talk to you for a bit, and Mr. Dwayne can come back up, and I don't have a chance to say anything else to you. This is it for me. After Mr. Dwayne finishes the next time, then the judge will instruct you as to what the law is. And it's very important that you listen to what the law is. They're called jury instructions. And the judge is going to talk to you, about what the law is, and I may go over some of that with you. But what I want you to first understand, or to also understand, is you will have a copy of the indictment with you. where you yourself will get to read the indictment. Of course, the judge has read it, and we've heard all about it, and it's important. It's important that you pay close attention to the language of all of the counts in the indictment. First of all, understand, and I'm glad Mr. Dwayne mentioned that the statute of limitations on some offenses is 4 years. As we know, this offense, the child died, Karter died, on November the 17th of 2020. That's when COVID was going on, if you remember. Okay? This case was indicted by the Houston County Grand Jury on October the 18th of 2023, almost 3 years later. And of course the state will say, we returned this indictment, it was returned within 4 years. Okay? But think about it. 3 years later, here we are, July of 2026, the case is finally going to trial. And you have to think why. Okay? Of course, the state can get up and argue that they did everything they're supposed to do, and the fact that the sheriff's department did their thing, and then it was submitted to us, and it was the grand jury that didn't return the indictment until October of 2023. But in any event, timelines are always important in everything in life, okay? In everything we do. And like I say, you need to be mindful of the fact that here we are, some 6 years later, after the child has died, that this case is going to trial. Okay? Now, you'll have this indictment, and I want you to read over it. Read over it carefully. And the state has to prove all of these charges against Ms. Davis beyond a reasonable doubt. And that's part of what the judge will explain to you is what does reasonable doubt mean? What does it mean? And the judge will tell you what that means. She's not going to tell you that it means doubt to a specific number or to a mathematical certainty. She will tell you as reasonable doubt means exactly the type of evidence that you need to consider when making your decision as to whether or not the state has proved each and every essential element of each crime charged beyond a reasonable doubt. All I ask you to do is, of course, you've heard the evidence, is follow what the judge tells you. Just follow what she says, and she will tell you what the law is. The first charge, as Mr. Dwayne has said, deals with malice murder, malice aforethought. And I think Mr. Dwayne was, I guess he was saying when he was telling you that my client beat this child to death. Beat this child to death. And the judge will explain to you what malice aforethought means. She'll explain that to you. But that's what the state is alleging in count one, that Miss Davis beat her own child to death. And of course the state has said that they don't have any eyewitnesses or any factual evidence or direct evidence of that nature, that it's all circumstantial. And the judge will tell you the difference between direct and circumstantial evidence and what can be used. We understand that. But the burden is on the government to prove the charges as to malice murder. Malice murder is in our way of doing business in the state, that's the most serious offense that the state can charge somebody with. For beating someone to death. I mean, you see malice murder in cases where someone's been shot or been pistol whipped, or I mean, and the state has said that they have no theory on what sort of weapon there was. Not that they have to, but they don't have that. So, I guess, you've seen Miss Davis in trial this week, and you've seen her testifying, and they're saying that either she did it maliciously, with malice aforethought, and they've also got Kiyon Benton charged with the same thing. He's not here. He's not here. Of course, they're being tried separate, but if he was there when this happened, then why is he not here to testify against Miss Davis? Because it didn't happen. Malice murder. The most serious of any murder that there could be in our state. The other charges, 2 and 3, felony murder with the separate predicate offense being cruelty to children in the first degree, and then count 4, felony murder, the predicate offense being count 5, aggravated assault. And of course the indictment here says in felony murder that the child was beaten with an object the exact nature of which is unknown to the grand jury, caused cruel physical pain, that being a lacerated liver to the victim. Well, circumstantial evidence is what they've established. And circumstantial can be okay. Not in this case. Aggravated assault being circumstantial evidence that the child was struck by an object unknown to the grand jury. Okay. See, you sort of need to break down you either have a malice murder, you have a felony murder with these underlying predicate offenses, or you have what's in 5 and 6, which is an unusual charge in our state, but it's a valid charge of murder in the second degree. And you'll need to read the indictment on this one, that murder in the second degree occurs irrespective of malice, meaning there doesn't have to be malice. You have to show, or the state has to show, that they have established that the child suffered cruel physical pain by the failure of the mother to seek immediate medical attention. There has to be criminal negligence there. Criminal negligence. In other words, the state says something about wanton disregard or just not just failure to act, but intended to act that way. And I submit to you, ladies and gentlemen of the jury, that they have not done that. They have not done that. I'm telling you, Miss Davis is guilty of nothing. Now, once again, the burden of proof is always on the government to prove these charges, all of these charges, beyond a reasonable doubt. I'm not going to, and I don't know what Mr. Dwayne's going to do because he goes after me. That's the way that this works. But you heard the evidence in this case. And as things go, a case of 3 days in a murder case is not that long. But still what's important is what you gathered or what you gleaned from the witness stand. Okay? You heard, let me mention this. Timelines are important, as I mentioned before. Miss Davis and Mr. Ambrose, to together conceived this child, and this child was born, as we talked about, on January the 14th of 2018. So 9 months prior to the child being born, Miss Davis became pregnant with Mr. Ambrose's child. Okay, and during that time, they moved in together at an apartment over at Sandpiper Apartments in Warner Robins. Okay, Mr. Ambrose was working at the fire department as a firefighter and EMS. I mean, he was doing that. And you heard Miss Davis testify that she was, she was taking classes, and she had worked some at FedEx and then worked at a place in Macon, a dermatology place. And that the child was born January, like I say, January the 14th of 2018. While they were still living at Sandpiper Apartments. That they continued to live there, and you heard the testimony from Miss Davis that I don't think I'm being derogatory by saying that the child was somewhat sickly. Okay. I mean, there's some things that we've said about sickly, and the state wants to be critical of Miss Davis because she called her child a crybaby. I mean, so what? So anyways, the child was born January of 2018. The relationship between Miss Davis and Mr. Ambrose continued on until March or so of 2020, when it just ended. And by then they were living over there at Lakeview Road Apartments, whatever the name of those apartments are. But it's important to note that these apartments are right next door to this pediatric place. And you heard Miss Davis testify that that's one of the reasons why she moved over there, so she would be near where her doctors were for the child. And you'll have, and the state put into evidence, and you'll get these. The State's Exhibit 1, more than 40 pages of documents from when whenever Karter started going over there to the pediatric place. And y'all can look at it yourself. The state put it in there for you to look at. I mean, Miss Davis isn't being disingenuous or dishonest with you by saying that she was over there at the doctor's office quite a bit. She was concerned about her child. Okay? I mean, all these instances of her taking the child to the doctor. And the state wants to come here and say that she's wanton and willfully disregarded the life of her child. That doesn't make any sense, folks. Doesn't make any sense at all. Now, one thing that is important to understand too is that Miss Davis is raising this child as a single mother. You've heard some testimony that, for the most part, her and the father, Mr. Ambrose, got along okay, and they agreed on the amount of child support to be paid, and that he was paying it. And then at some point in time, the decision was made, October or so, right, the month or so before the child died, that maybe he needed to be under a child support order. I mean, that's just, a lot of times the state will want to bring up things sort of like a red herring or a smoke screen or something to try to take your eye off the prize. Okay? You know, and you can take it for whatever it's worth, any sort of problems that Miss Davis and Mr. Ambrose were having with each other, you know, in the day or so before the child died. You can do whatever you want to with that, okay? I mean, if you know, there's some reference to a text that was sent by Miss Davis, and the F word was used. Okay, we've never heard that before. Okay. I mean, I guess that makes Miss Davis the worst person in the world to use the F word in a communication with the father of the child. Making a mountain out of a molehill. So I think the evidence was that, I mean, I'm not going to go back through all the days before the child passed. Y'all heard all that. And we didn't go over when Miss Davis testified today, because the state put up the videos, the video interviews that she had with Sergeant Collins on the day after the child passed, and then, you know, about 2 or 3 weeks later. Okay? Y'all got to hear all that. I mean, that's as raw emotion as you can get. Okay? And I guess the state's going to say that she was just putting on or making it up, but she didn't care about her child, and therefore the indifference or the criminal negligence, therefore at least murder in the second degree. And folks, that's for you to decide, not for me to decide, not for what Mr. Dwayne said. See, what I say is not evidence. What he says is not evidence. You have to decide the facts and the truth. We'll never know what the truth is. No one will ever know what the truth is. You know, other things that you need to be mindful of too, and I appreciate the attention. You know, the set of facts in this case is just different. That, I mean, you heard that Miss Davis, in her job, she worked for the Central Georgia Technical College, and she was assigned or sent to different high schools in the area to help them with their computer science classes. Okay? And you heard her testimony that she received a bachelor's degree from Mercer and also a master's degree from Mercer. Okay. And that the way that the facts happened in this case, that she had gone to work up in Jones County or in Milledgeville on that particular ill-fated Tuesday. And that she had been trying to get in touch with Mr. Benton. Finally got in touch with him, and they FaceTimed each other. I mean, you've heard all that. There's no sense in me going back over it. And so Mr. Benton put the child in the car and drove 2 or 3 minutes to the pediatric place for an emergency like this. And that basically the whole time Miss Davis was on the phone with Mr. Benton, and she even heard some of the conversation when she got into the pediatric place. I don't know if it was Miss Sledge or Miss Baker or Miss Gaddy, whoever it was, that Miss Davis recognized that there was a problem and she had to get back. Okay? And I'm grateful that all the folks from, or those folks from the primary pediatrics came and testified and told you what they heard or what they knew. I appreciate that. And apparently they did what they could to try to save the child's life. Okay? But at some point in time, the doctors there, Dr. Ford or whoever, recognized that they wouldn't be able to, that they needed to get someone else that called 911 and get someone, and you heard the rest of it. Okay? And like I say, you also heard from Lisa James, who was over at the Peach County Emergency Room, and she testified that the child was unresponsive. And she said what she observed. And you can remember for yourself what she observed. And also the others that testified from the pediatric place, what they observed. But once again, you'll have all the documents from the place for way on back, for when the child first started needing medical treatment. Okay? Now, what's important to note is that, after Karter had passed, and Miss Davis and Mr. Benton went back to the apartment, and Officer Wartell from the Warner Robins Police Department was there, and you heard their conversation. Once again, their conversation with Miss Davis and also with Mr. Benton was important for you to see. Once again, raw emotion at its highest. Okay? And we're grateful to Officer Wartell for being there to offer the comfort that he did. That's important to know. Trust me, it's important to know. And they were waiting, Miss Davis was waiting on Sergeant Collins to come back so he could search the place. And if you remember, he hand wrote or prepared a consent form where Miss Davis consented to let him, Sergeant Collins, with the Sheriff's Department, go in and search and look at everything in the apartment without any restrictions or just go in there and do it. Okay, you heard the testimony from Officer Herrera or Investigator Herrera, and you'll have with you State's Exhibits 15 through 61, I believe. All these photographs that we looked at the other day. And you'll have them back there to look at. Okay? All right? And you saw where there were certain places where it looked like, excuse me, that the child had either thrown up or vomited or spilt some of his orange juice or whatever it was. You'll have all those pictures. And you heard Investigator Herrera testify that he took samples from the carpet, cut out samples from the carpet or from the bed or from the pillow. Have any of them been shown to you afterwards? Folks, after Investigator Herrera took all that information, or all those samples or whatever it was, he took them back to the Warner Robins Police Department, put them in a vault, and nothing was ever done with them. And what does that matter? Well, if you're investigating the case from law enforcement, and you're getting a pile of stuff to look at to see as to whether or not there's blood there, or if there's actually, to determine what you find, then do something with it. Did they ever submit anything to the GBI? No, they didn't. You heard Sergeant Collins testify that he left in February. He didn't do anything with any of that. And Lieutenant Meadows testified he didn't do anything with it. Well, who else would do something with it? Now, Mr. Dwayne said that there's been some things that have been a little odd. That was odd. You go to all that trouble, 2, 3, 4 hours, however long Investigator Herrera was there, and collected all this stuff, and then didn't do anything with it. That proves nothing. Nothing. Proves nothing. You know, and like I say, folks, you can look at these pictures, and of course they're just duplications. You saw one from one angle, one from another, and one that had something that was like a measuring stick or something. You got to figure out if it means anything or just a waste of time. You know, once again, this child passed away on November the 17th of 2020, and within a day or two, Dr. Brown, who granted is part-time and lives in Ohio and comes down here periodically to do autopsies, did the autopsy and gave a report, and he testified as to his report. Okay? And that Dr. Eisenstadt, who was his superior person there in that department, I guess he was called upon because there was such a delay in the report being completed that he got involved, and you heard all about the Zoom meeting that Dr. Eisenstadt and the other doctors and the DA's office and the sheriff's department all had, and came up to the conclusion that this is a homicide. And that report was issued 10, 11 months later. Okay? All the while, the testimony from Ms. Davis was she was calling the sheriff's department trying to find out what was going on with the death of her child. Nothing. Crickets. That's what she got. Crickets. And you know, at some point in time, the doctor finished the autopsy report after there had been peer review by Dr. Eisenstadt, and within a couple of days they finished the report, and then 6 weeks or so later they sent it to the sheriff's office, and by that time Lieutenant Meadows had the file and was working on it. Okay? So, I mean, really nothing else was being done on it, and Lieutenant Meadows calls Miss Davis. She's up in Gwinnett County teaching school up there, Peachtree Ridge High School, and says, "Can you come down here? We've got some other information to give you." And of course they go over all that, and you saw the video. And of course Miss Davis, questioning what happened to her son, asked for a copy of that. Did Lieutenant Meadows give? No, wouldn't give her a copy. What's he hiding? Give it to him. I mean, what's wrong with taking the report, putting it in a Xerox machine, and giving it to Miss Davis? And then you heard the statement that Lieutenant Meadows said that, "I'm not going to give it to you. And I don't know if we're even going to give it to your lawyer." And of course the state can speak to that, but you can remember what you heard. You know, what are they hiding? Why is it taking so long? So anyways, there that is. When Lieutenant Meadows had his conversation with Miss Davis, it's December of 2021. I guess Lieutenant Meadows sends everything to the district attorney's office, and that case is there for 2 years before it gets indicted by the grand jury. And the state may say, no harm, no foul. I mean, the whole time you've got a grieving mother here, and I think we can all agree that people grieve in a different way. I'm not going to make fun of anybody for grieving the way that they grieve. But here it is, basically 3 years after the child dies, the case gets indicted by the grand jury, and Miss Davis gets arrested then. 3 years. October or so of 2023. Here we are almost another 3 years later when we get here. Okay? And the state would have you believe, don't worry about it, nothing to it. Folks, there is something to it. That's for you to decide if that's something that you'll tolerate as citizens of this county. Once again, the burden of proof is always on the government to prove the charges beyond a reasonable doubt. Okay? And I don't mean to bore you with what I'm saying. Okay? You know, there's the way that I was raised, if there are flies on something, then there's a problem. Okay? And there's flies all over this. You know, and of course, the state, and I appreciate Mr. Ambrose being here, and I can appreciate, you know, I think the state was concerned. That's why they brought Miss Tharp in, who babysat the child, saying that there's nothing that happened to the child, and they wanted to. You know, the Dr. Eisenstadt and other doctors say that the death occurred within 24 to 72 hours of the attack or the beating of the child. How do we know? I mean, there's no way, as a lawyer, that I can match medical wits, if you would, or medical knowledge with the doctor, the pathologist who did the autopsy, and then the one who was his supervisor that approved it. How can I match wits with that? I'm just asking simple questions and making simple statements. But the state, in trying to prove their case, has to always try to put a wedge. You know, that's why they brought Miss Tharp in and bringing all this up about, I mean, you know, what is, I mean, Miss Davis is grateful that Miss Tharp made a pillow with the child's picture on it or a T-shirt or something. She's grateful for that. But why make it into something that it's not? Folks, we will never, ever know what happened. We'll never know. And I'm almost through. Let me just say this. Of course, Mr. Kennedy came in. That's Miss Davis's grandfather. Nice old guy. Nice old guy. And Miss Davis lives with him. He's taken her in. But you know, I mean, it's been 5.5, 6 years that his grandson has died. He doesn't remember everything. I mean, folks, he's a nice guy. I mean, but I'm glad he was here. You know, once again, you know, after all that, you heard from the police officers in this, and you can take whatever you want to determine the guilt or innocence of Miss Davis. I mean, you know, we understand what Heath Collins had to say. he had the case, and he worked it pretty strong, I guess, for a couple, 2 or 3 months, and then he left. And I submit to you, the case just sort of sat there. You know, there was some talk about, you know, from Dr. Eisenstadt or the other doctor, Dr. Brown, that did the autopsy, about whether or not it was homicide. But you know, the word homicide kept coming up, but also the word undetermined kept coming up. If they had decided that it was a homicide a month or so after the child died, and they got the reports back on toxicology and these other reports that you heard mentioned from the GBI, why didn't they do something then? You know, Sergeant Collins leaves, Lieutenant Meadows picks it up, and really nothing is done with it until the Sheriff's Department says they're waiting for a final autopsy report. Okay. I think we've all been around a little bit and know when someone's trying to pass the buck from one to the other. Okay? So anyways, the decision is made, as I mentioned before, and I'm going to be finishing in just a short bit, Judge, that Lieutenant Meadows gets Miss Davis in her office in December of 2021, and at that time he determines that she's a suspect. You know, but he takes a statement from her, doesn't give her Miranda rights or anything, because she's not in custody. That's the golden ticket there. She's not in custody, but that. She's a suspect in his mind, but he just goes ahead and tries to clean up some questions that he may have from the previous interviews that she had with Sergeant Collins. And then for another almost 2 years, nothing else is done on it. The whole while Miss Davis is up in Gwinnett County teaching school at Peachtree High School, and then she mentioned the other school that she helped open up, a brand new school up in Gwinnett County with computer science. Okay? And then at the point in time where they arrest her, I mean, she's out of work. I mean, she can't, I mean, once she's charged with this, I mean, she's out of work. And so she's waiting. And she appreciates your patience in being here. She appreciates the attention that you've given to her in this case. And like I say, if there's anything that I've done that I've said, hold that against me, don't hold it against her. I'm just trying to help her the best I know how. You know, I'm getting ready to sit down, and the district attorney's going to get to come up, and I don't know how much longer he's going to go, but you know, you'll have all these photographs, all these documents, and you have to decide for yourself as to whether or not the state of Georgia has met its burden in proving these charges against my client, all these charges, beyond a reasonable doubt. If they haven't, then she should be found not guilty or acquitted of these charges. It's sad that this child is gone. Miss Davis' only child. Okay? You know, I'm going to leave you with this one thing. I've tried cases down here for a long time, and I always tell people that don't leave your good common horse sense at those doors when you come through to serve. The judge is going to give you the law. You heard what the state has put up. You've heard Miss Davis as she's testified. But use your own sense in making a decision about this. Follow the law, follow the facts, and when you get back there, we would ask you to find Ms. Davis not guilty of these charges. And we thank you for your time.
Stop emailing me. Now you can't get or talk to Karter. Leave me the F alone, and that's the last time I'm going to tell you. Never to talk to his child again. We'll never know what happened. Is that really true? Quarter-inch rectangular red abrasion on the right external nair. Quarter-inch square red abrasion on the lateral aspect of the right upper lip. 1/8 inch irregular red abrasion on the lateral aspect of the left upper lip. Oblong red contusion to his cheek. Red contusion on the right chest adjacent to the sternum. 1-inch round red contusion on the midline upper abdomen along the costal margin of the ribs. 3/4 inch round red contusion on the right upper abdomen along the costal margin. Another separate distinct injury along with the cage ends. Blue-green discoloration on the midline abdomen. Red contusion on the abdomen overlying the umbilicus. 1/4 inch round squared red abrasions on the underside of the scrotum. Red abrasions on the right mid-abdomen. Internal hemorrhages reflected on the scalp. Right posterior parietal. And then another one. Multiple. Interior abdominal wall muscles, adipose tissue, and mesentery. Extensive hemorrhage. 2 1/2 inch gaping laceration of the liver, the attachment of falciform ligament. Blood in the abdominal cavity. Pancreas hemorrhage. Testicle and cord hemorrhage. Patchy serosol congestion hemorrhage on the small intestine. But we'll never know. The medical examiners told you exactly what you needed to know. And Mr. Groove is absolutely right. You don't leave your common sense at the door. It stays with you. And common sense is that Kianna denies doing it herself, but she doesn't blame Kiyon. She defended him. And those are the only two people who had access to this child when the trained expert medical chief examiner tells you that this injury could have occurred. And her original statement that he had throwing up on Sunday night, not Monday, not a convenient change in her story to Monday when Kiyon was home with him, but Sunday, when it was her or Kiyon who had access to him. Common sense. It was either one or the other or both. And her testimony was really telling. Her evasiveness, confrontational, the fact that she wouldn't even say her own child's name. This poor mother who's lost her only child and she can't say his name in front of you. She just didn't know. She's just oblivious. She had no idea. She didn't think anything was wrong. But yet, she claims that she moved to those apartments to be closer to the doctor. Because he has asthma and allergies. Like a whole lot of other kids do. And that she's always paying attention when something's wrong. that she calls 30 million times a day. All of that vanished that weekend. And that's exactly why she wouldn't let Kadeem see her son. His son. Their son. Now, it has become apparent to me that the defendant's main argument as to why she didn't do this is because she's had to wait too long. That's the only consistent argument that has been made. Not about the facts as to what happened to that child. There's just been argument after argument about how long it's taken the state to get this to trial without offering any real context to it. Without offering any reasons why. If there were any other issues that came up beyond the state's control. Doesn't bother bringing anything like that up. But justice has no expiration date. Karter's life had the expiration date. But this trial does not. You want a smoke screen? There it is. That's their smoke screen. Be mad at the state. Don't be mad at the two people who had custody of this child when he suffered a 2-inch laceration to his liver. Don't pay attention to that. It just took too long. That's not even what the law says. Reasonable doubt. The judge is going to tell you it's not a fanciful doubt. It's not to a mathematical degree of certainty that the state has to prove this. Alright, this is where your common sense comes into play. We did bring up motive. The state doesn't have to prove a motive. It's not a legal requirement. It is not a legal requirement that the state prove motive. Or premeditation, for that matter. And then they bring up the fact that Kiyon Benton isn't here. Well, I'm not the only person in this room with subpoena power. With the power to compel someone else to come in. So do they. You don't know the weapon. Yeah, I mean, I thought that was pretty evident from the moment y'all were sitting out there when the judge read the indictment to you. That's no secret. What we have is hemorrhaging on the head. We have multiple blunt force impact injuries to the abdomen. It could be anything. It could be anything. And you don't even have to pick what it is. Hands are the most obvious, but you don't even have to make that decision. All it has to be is an object, the nature of which. And the nature of those injuries, it is clear that a hand or other object was used to inflict them. This defense argues murder too is weird. No, not really. Not if you think about it. Not if you think about what duty a parent has to their child. Their 2-year-old child. I'm not sure if there's legal duties as it relates to, children who are 30. But a 2-year-old who relies on his mother for protection. A woman who claims that she moved close to her doctor's office. Who said that throwing up in his sleep was a red flag or it was abnormal. But then in the same breath said she didn't think anything of it while she was lying to y'all on the stand. A woman who took her child to the pediatrician all the time, who had him hospitalized, who watched his allergies, who gave him his breathing treatments when he needed. The absence, randomly, of her give a damn is telling. Yes, when your 2-year-old child is in that much pain, you have a responsibility to seek medical care. And she did not do that. Reckless disregard for how the pain that he is experiencing may affect him. And we know waiting hurt. We heard that testimony from the medical examiner. It hurt bad. I think it hurt a lot worse than she was saying. I don't think there's any way he was letting on that this was just a little stomach ache. And that caused pain and pain and more pain until he died. Whether or not you want to pick a winner and a loser, who did this, who didn't, other than Karter, who's the victim here and who's not? Whether or not she actually knew or didn't know. At a minimum, she's guilty of murder in the 2nd degree for not performing her basic duty as a mother. Feed them. Give them some clothes. They don't have to be nice. Put some kind of shelter around them. Give them some medical care. She couldn't even meet that burden. But poor her, single mother, as though Kadeem was not an active father in this little boy's life. He didn't abandon her. Didn't cut ties. He wanted to be involved in his child's life. She took that from him. She testified. She lied. She lied. I asked her if she tried to get a new phone shortly after this. She said no. And then we went through pages of her trying to get her new phone. Records that she herself identified right after this happened. Multiple pages. Why suddenly do we need a new phone? To conceal. Why brag about the fact to Miss Shirley that the original investigator is no longer on the case? She's calling. She wants more info. More info. She's worried about herself. She knew that the arrow pointed to 2 people, and she was one of them. She's terrified that the state may come down on her. And then she testifies that if you call the pediatrician's office, you can't get an appointment the same day. That a pediatrician would never have the time. As though a pediatrician would never anticipate the fact that younger kids often get sick. Simple illnesses. But they can't just be seen. Oh, I gotta wait. I gotta wait. I can't get an appointment. Never mind the fact that she's a regular. Never mind the fact that she carried on and on and on about how awful it must be for them when she's on the body cam with Officer Whitell. She didn't even make an effort. Now they make an issue of the samples on the floor. They didn't send anything to GBI. Well, Karter's body went to GBI along with that liver, along with those bruises, those hemorrhages. And what is interesting is that all of a sudden here, well, we don't know if he was throwing up or not. When she herself tells law enforcement in one of her interviews, yeah, I figured out he was throwing up. And now she wants to change her story on that. Every little thing she wants to change. She wants to fight. The question here isn't whether or not you tolerate how long it came to trial. The question is whether or not you tolerate a 2-year-old boy being murdered. That's the question. And you've heard quite a bit of testimony. Right? Remember, testimony is evidence. You heard about what was overheard by the primary pediatrics people. Don't worry about that. Just get here. Or I should have brought him when you told me to. Not sure why Mom is telling somebody else who's not biological father if she's there, like she said she was. Another man who she broke up with shortly after this, she didn't want to answer that question. She didn't want to answer anything. In fact, when I said nothing further, Your Honor, she went, thank you. A grieving mother. Common sense here. Two people had access to this child. And she says she didn't do it and that Kiyon didn't do it. Common sense tells you that statement makes no sense. They were hiding, covering up. Covering up. Whether she hit that child, whether he hit that child, at this point, it doesn't matter because one of them did it or both of them did it. But now we have the cover-up. She wants you to believe that she's such a good mother that she calls all these times a day. She always checks in. She drives from the office at lunch to get, to check on Karter while he's there. And yet she's got no idea. No idea. Ladies and gentlemen, there are plenty of pieces to this puzzle for you to see that she is 100% guilty of malice murder, of felony murder, and murder in the second degree. Thank you.